So the first clauses we're going to look at, we review a lot of employment contracts, and there's actually a change in the law, and it came into force in April 2020. And it set out a number of additional clauses that should be in a Section 1 statement, or usually the contract. And what we usually find is that because if you look at April 2020, that's 1 month after the pandemic started. So you tend to find that, this change was completely forgotten just because there were so many other things that everyone was dealing with in April 2020 than looking at your contracts with the new regulations coming in. So I thought I'll run through all the clauses that were included in that change, and then you can almost give yourself a bit of a sense check of, have we captured that, or is that something that we might want to now think about adding in? When we've looked at those new clauses that are required, we'll then go on to look at just more common clauses and some practical tips in terms of, things that people forget, more, practical things, so things that are, good to have in there and things that are often forgotten. So the first one, I've actually put the name of the regulations there. So these regulations came into force in 2018. And as I say, it was in April 2020, a month after the pandemic, that they came into force. So from then, these clauses are required legally. And the first one is actually a training clause. So with this, what it's really looking for is any mandatory training that the employer is going to provide that's specific and required for them to carry out that role. Obviously, that can be quite difficult because you don't always know what training is going to come up for someone. These things can come up quite naturally. So if you don't have a course that for that role coming in, you must complete X. You might want to include something more along the lines of, you're entitled to in-house training that might take place from time to time, and it would be about directing them to where they can find that specific training information. So, if it's not going to be listed in the contract, if it's coming up now and then, from time to time, whereabouts would they find that? So, would it be a particular manager that has ownership of the training opportunities? Do you have an online platform? So it would just be saying that it might come up and where they can find it. And obviously if there's any mandatory training, stating what that actually is. So that's the first one that became a requirement, and I tend to find that one's missed out in the contracts that I review. The next one's a benefits clause. So this is a new requirement. So I find that this one's missing quite often when I come to review. So this was brought in after the Good Work Plan, so a kind of government recommendation, and that said that the contract should have all remuneration, not just the salary. So when it's talking about benefits and saying what benefits are applicable to an employee, it's not speaking about things like, if you do free fruit in the office, or if you've got a pool table in your staff room. It's speaking about things that are economic in nature, so things that could have a cash value. So that might be things like if you have private medical scheme, a cycle to work scheme, if you have any sort of salary sacrifice schemes, those kind of benefits. So something that can directly be linked as economical. And what's quite strange in this one is that obviously not all your benefits will be contractual, and not every employee will opt to take that benefit. So in that scenario, what you would really be doing is stating in the clause, these are the benefits, the flexible benefits that we have available, that you might take subject to the rules of that benefit. And then it would actually be stating these benefits don't form part of your contract of employment and might be amended. So although you're stating them in the contract and listing the benefits that you have in place that's available, that it doesn't give them contractual effect if they're non-contractual, but you would want to state that underneath. And another weird thing about these is that after the law changed in April 2020, see if you don't offer any benefits, or there is no, specialised training, you actually have to state that. So you would still need the benefits clause, but you would be saying we don't offer any benefits as part of your employment. So yeah, they still need to be there, but just explicitly state you don't offer them. The next one is an other paid leave clause. Again, from the same regulations, this has been required since April 2020. And what they're looking for is other paid leave that you offer. So whether that's statutory or contractual. So the way that would usually look is almost a list, an A, B, C, D of we offer the following leaves. So that will normally be, statutory maternity, statutory paternity. I popped them on the slide there. You can see adoption leave. Just wanted to highlight the parental bereavement leave because that's a newer type of statutory leave. So if you already have this clause in place, it's worth checking that you've got that one on your list. And again, you're not having to put your full policy for each of these into the contract. You're just wanting to make it clear in the contract, in your list, that you offer them and where they might find the details of that if they want to use any of these types of leave. So if that's in your handbook, or if the policies sit with a certain department or staff member, you would just say that. Just put a wee note there to be aware that there's new types of statutory leave coming in place in 2024, such as the statutory carers leave. So if you do have this clause for anyone who comes in next year and you start, you might want to revise their contract to make sure you've got your list up to date. Again, it's worth thinking about any contractual paid leave because the clause, it's not just statutory leave, it's any paid leave. So if in your policies you give any sort of compassionate leave that attracts pay, or any paid study leave for any training roles, things like that, that should also be in the list. So that's all. This clause is also needed just to make sure that you're compliant. The next one, again, the next one that's been brought in from those regulations is a probation clause. So you tend to find that if someone's on probation, that they'll already have this in. But again, it's that thing of if there's no probation period, they're still requiring that someone's contract makes it explicitly clear your role does not feature a probation period. So even for those who are not on probation, you want to be making a mention of that. The way that the legislation's worded is that it must set out the conditions and duration of the probation period. But I've just popped down there some additional things that you might want to think about in a probation clause. So that's things like making sure you've got the notice. So what's the notice period going to be on probation? Usually that's a bit lower from what I see than that's one of the kind of key features and benefits of a probation clause. So you might want to clearly set out what the notice is while they're on probation. The next one, policies and procedures. Quite often, if someone's on probation, will alter the way that they're treated under certain policies and procedures. So for example, when they're on procedure, does your normal absence procedure apply? Does your normal disciplinary procedure apply? Because they might be experiencing a shorter process. So it might be worth stating if there's any policies that they're excluded from while they're on probation. The next one, in your probation clause, I think it's always good to give, yourself a contractual right to extend if there's a period of absence. So, if someone gets unwell on a 3-month probation and they're off for 4 weeks, you might want to add that 4 weeks on at the end so that, you can get a good, fair assessment of the employee during that period. If you don't have the contractual right, you would really need to have that agreed with them. So I think it's good just to have there to make clear that you might want to exercise that right if they are off. And then the next thing that I think is good to see in a probation clause would be just saying that, the outcome will be confirmed in writing, but that if they don't receive confirmation in writing that they've been successful, they should assume that their probation's continuing. And that's just to save any sort of, disputes when you think they're still on probation, but you've been a few days late with the meeting, or giving out the outcome, and there's a bit of dispute there. So I think that can be helpful to clarify that as well. The next one that's been a requirement since April 2020 is an hours of work clause. Now, you'll most likely already have an hours of work clause, but what the key change that they've asked for is that it states the days of the week the employee is required to work. So that's obviously quite easy if they work Monday to Friday. That might be a bit more difficult if they do shift work, if they're on a rota, which is common in our industry. So what they've said is that if the days are variable, it must be stated clearly that they're variable, and details of how they might vary. So if they're on a shift, what are the different shift patterns, these kind of things. You usually find that that's mostly already captured in the hours of work clause if someone's going to be on shifts, but it's just worth having a look at your hours of work clause and seeing if it does make clear that their hours or days are going to vary. Just a kind of a note of that's something that I see quite common in an hours of work clause is that, if they are going to attract overtime, you want to state what are the rules on the overtime. Is it, paid overtime? Or if they're more of a salary role, it's likely it could be, a reasonable expectation to do some unpaid overtime if necessary for the needs of the business. So if there is some expectation of overtime involved, just make sure that's captured. And then again, if you are putting wording in for overtime that's paid, you want to make sure that you've stated any overtime premiums in your pay clause so that they can look to their contract and see what exactly they'll get paid if they work that overtime. Now, in this clause, I often see, that statement for the working time regulations that says you agree by signing this contract that you will opt out of the 48-hour maximum weekly working week. So if that's in, I would advise to take that out and put that in a separate document. The reason being that it's been kind of deemed to be less enforceable because they're essentially signing away their rights under the working time regulations. So if that's lumped in with a big contract with a lot of information, it's a lot less likely to hold up. Whereas if it's a separate document, it's more easy to demonstrate that they've considered that they're opting out of their rights in the working time regulations. So my advice there would be check and see if you have that in, and if it's in, pull it out, and put that into a separate document. So moving on, the next clauses, these aren't clauses that have came in new. It's just a look at some clauses that quite often see some errors in, or things that could be added to make it a bit better. So I've popped in some legislation there. In Section 13(1) of the Employment Rights Act, they set out the ways in which an employer can deduct sums from an employee's wages legally. So, if there's any money that they owe, to be able to actually deduct that money. And what they say in the Employment Rights Act is that the only way you can take money off someone's wages is if you have that ability in your contract of employment. If you're taking it off from statute, so for example, tax and NI deductions, you're obliged by statute to make those, or because you have the agreement of the employee. So with this, what you can find is that if there's a situation where there's been an overpayment, you want to deduct sums from an employee's salary. If you don't have a clause in your contract which gives you the contractual right to make that deduction and they won't agree to it, you're in a situation where you're in unlawful deductions territory. So you really need to have in a deductions from wage clause. So that can be a sub clause within the pay clause, it can be standalone. But what that's really doing is just authorising the company to make deductions from the pay for any sums owed. So you might want to say some examples of times that the company might want to use that right and deduct from wages. So that could be, if they've overpaid the employee. That could be any repayment if there's been any advance or loan. They might just want to deduct the repayments from salary, or if there's any damage or losses that have been suffered by the company because of the employee. So you really, to have the kind of legal basis to deduct sums, if you don't have their agreement, you really need to have this in place. And it's worth mentioning that unlawful deduction from wages is a standalone claim to the Employment Tribunal. So that means that, if you do deduct money off someone's monthly pay, weekly pay, whatever it is, and you don't have this clause or agreement, they can actually fill in an ET1 form and make a claim to the Employment Tribunal for that. Holiday clause, again, I've not stated the bare bones of what holiday clause would look like, just pointing out some more complex things or things that are a bit more interesting to discuss with you today. So the first one I've popped down there is that it's good to state your position for carryover leave. So the way I see it done, and I think it works quite well, is give an express right to carry over a certain amount of days. So for example, that could be 4 days, and then stating that while you have 4 days to carry over, any further days are at the business discretion. I think it's always worth to state that there's an exception there, because obviously if someone's prevented from taking sick leave because of sickness absence, or they've been on a period of maternity leave, they'd be entitled to carry over their leave. For sick leave, that would be limited to 4 weeks, and you would take off any days that have been taken in the holiday year that's just ended. And again, that carried over holiday would be lost if it wasn't taken in 18 months. So it's just good to have some wording in to reflect this. If you do allow some carryover leave, to put a limit on how much can be carried. And also, if you don't allow carryover leave, just to make it explicitly clear in your contract how you're going to deal with that. For public holidays, I thought this was an interesting one to point out, because we actually ended up with a lot of calls about this last year. The reason being that, some years the amount of public holidays we get is more than the average. So I think there was one year we had the Queen's funeral and we had the Jubilee. So it was just working out, are your employees entitled to that? And what was quite interesting for me was that it really turned on one word. So if you have a look at your contract, if yours says something like you're entitled to the usual public holidays, or 8 public holidays, or the recognised public holidays in Scotland. So if you're using words like usual or all, that would kind of make a difference. If you've put all, then that would say, as it means, all public holidays. So when new ones are announced by the government, they'd be contractually entitled to those holidays. But if you've put that they would only be getting the usual or 9, there might be an argument there to say, no, it's the normally recognised ones, or it's only the eight recognised ones. Now there's 10. The contract only makes provision for 8. So whether or not people, if you're ever in a problem with this, it's really looking at the precise wording of your contract, because that will really be what it turns on. And that's what we found when looking at kind of multiple employment contracts from different organisations. The difference in whether or not they're entitled to new public holidays usually came down to just a word. So for notice clause, again, just conscious of the time, we've got a lot to get through, so I'll just kind of take us through the key things that I've picked out that I thought's useful to point out to you. So first of all, just stating, what their notice is, which sounds obvious, but sometimes it will be the statutory notice, and I've just popped down there in orange what the statutory notice is, or some organisations might opt for a contractual notice. So, they might want something more generous than this. But a kind of area that this causes issues sometimes is stating what's the pay going to be in the notice. So is that going to be basic pay or normal pay? And that really comes into that right to make a payment in lieu of notice. So it's advantageous to have an express right to make a pay in lieu of notice, and that would really kick in when someone, you're maybe making a dismissal, you don't want them to work their notice period in the business, so you just want to have the ability to, so for example, if they have like a 4-week notice either way, to pay them 4 weeks worth of notice pay, and then that their leave date will be on the date you make that payment. So I think if you've got the right to make a payment in lieu of notice, that's good. If you don't, I would think about adding it in. But I would make sure you make clear, is that going to be normal pay or basic pay? And where we see this sometimes crop up is in settlement agreements. So you'll often make a payment in lieu of notice there. And if your contract doesn't say it's basic pay, that would normally be an average of the normal pay, which could have overtime and things like that. So it's just worth making sure that you're aware of what pay is associated with your pay in lieu of notice. Because quite often when we're in that scenario, the employer tends to not be quite sure what it is. So it's worth adding in if you don't have it and having a think about pay. So the next one, I've added an exclusivity clause, mainly because there's been a change in legislation on this. So you might find that you've got a kind of old contract kicking about that's now uncompliant. So an exclusivity clause is one that, you know, prevents an employee from gaining a second job with another employer. So it can either be worded as an outright ban. So, you know, it can say, you know, we do not allow our employees, or you shall not have a second employment while in employment with us. Or it can say something like, you shall not have a secondary employment without the written consent of the company. So, you know, it can be an outright ban, or it can...
Hello.
Sorry, I'm just getting some background noise through.
Hi.
Got it. So yeah, it can be an outright ban, or it can just require that they come to the company for consent before they actually go on and sign that contract with a new employer. The reason I've added this one is because it's always kind of been banned for 0-hour contracts. So obviously if someone's not guaranteed work, it wouldn't be very fair to then prohibit them from having secondary employment where they could, you know, get some work. But now, as of December 2022, they've actually banned exclusivity clauses for those that earn under that weekly lower earnings limit. So right now it's £123 per week. That can change year on year. It's announced by the government, but it's just worth being aware that if their earnings are now creeping below that, maybe they've changed their hours, I would just make sure that their contract doesn't have anything like this in. Sometimes you find that their contract templates, you know, they might just be clauses in them, more boilerplate clauses that are being issued to everyone, but it's just worth having that check that if you have someone who's on, you know, a contract with few hours, that they don't have any of these standardised clauses that are unlawful. The next one I'll take us through quickly is a place of work or mobility clause. I think I've given an example down there in orange, and that just, I've used West George Street, so that's where our office is. So you'll see here it says your normal place of work is West George Street, Glasgow, or such other place within the central belt which we may reasonably require for the proper performance and exercise of your duties. And then also there's just a sentence under there that also says that, you know, you agree to travel as may be required for proper performance as well. So what this is doing is just giving a bit of flexibility to require the employer, to move the employee within that reasonable area. So here it's, you know, Glasgow or within the central belt, and that just means, you know, if you know one of your sites is having a downturn, you want to move them to a site in a reasonable area, you have contractual coverage to do that. The reason really I thought best to point that out is that sometimes you can have this clause and lean on it quite heavily, but it will be assessed in terms of reasonableness. And if, you know, you're deemed to have relied on this and used it unreasonably, so, you know, if that's going to require an extra 3 buses, if it's going to require, you know, them to relocate, you know, all these things that factor into the reasonableness of the request of where you're asking them to go. If it is unreasonable, there's a risk there that you might breach that implied term of trust and confidence with the employee. So it's worth just being aware that if you do have it, to make sure it is used with consideration and reasonably. Restrictive covenants, that could really be a session in itself, and it actually probably would be quite a good one. So I'm really going to do this very basic, but it's best to take specific advice if you're not so sure on this. So the most common ones that we see in UK employment contracts would be non-solicitation, not enticing the business or customers away from previous employer. Non-compete, so not going and working in a business that's a direct competitor. And non-poaching, so not leaving and trying to take all your best people with them when they're in their new role. So I think that the key thing here is you can see a lot of restrictive covenants that are what we call boilerplate, so just a copy-paste job of what your standard wording is. But these are actually a bit more difficult to be enforced than the average employment contract clause. If you want to enforce your covenant in a civil court, it must be reasonable in scope. So, if it's just a generic one, it is less likely to be enforceable. So that's things like the geography. So if it's a non-compete, what is the radius on that? Is that reasonable? The duration. So we'll speak more about that in a moment, but if it's unreasonably long, 6 and 12 months can be a long time after someone's employment to be in a covenant. So that's the kind of thing that will be looked at. And then the last one is, the employee's influence and what's the risk to that specific employee. So quite often you can see these in more junior level staff, and I think it's just been there because it's in all the templates, but it's just worth noting that if it's a more junior employee, they don't have very sensitive business knowledge, it's unlikely that that could be enforceable. So what they're really looking at is that there's a real risk to the business. So, do they have really sensitive design information, really sensitive business information that they could take elsewhere? So, they're really looking at these types of things to determine if it's reasonable. And if you're unsure on that, it's a good one to actually read the case law and how these play out in the courts to see the types of things that were held to be successful and unsuccessful. But what I tend to pick out is if it's been drafted specifically for that employee and you can demonstrate that some thought's gone in to actually having, analysing a bit what's the risk with this employee, in some way to demonstrate why you need the covenants you've put in, and it's bespoke for that employee, is going to be much more likely to be enforceable. And again, this year in May, the government has confirmed that there's going to be a statutory cap of 3 months on non-compete clauses. So if you have one that's 6 or 9 months, when this comes into force, it's not in force yet, it's just been announced. When this comes into force, they won't be enforceable anymore. The cap on non-compete will be 3 months. And finally, we've got the garden leave clause. So with garden leave, if you don't have this in, it might be worth having a think when you're drafting your contracts. Do you want to include a garden leave clause? And what that does is give the employer the contractual right to place them on garden leave, and it's normally for the duration of the notice period. So that means that they'll not be in the place of work, they'll perhaps be at home. And just some key things about a garden leave clause would be that they're still bound by the terms and conditions of the contract. So even though they're spending, for example, the 3 month notice period at home and not on premises, their employment contract's still going, and it's still valid, which does mean they'll normally attract their full pay and any benefits associated with that employment contract. Again, during this period, you might want to put in your clause that they're not required to undertake any work, and that they're not required to come on the premises during that garden leave. But again, I've popped down here some considerations. So even though a lot of the time these clauses state that they don't need to do any work or attend, it's worth having a think. Is there any work? Do you want to carve out a part in the clause to say, if there's any specific requirements of the business for a smooth handover, you must be contactable and available to assist. or if there's any work you want them to do for the handover at home. It would just be having a think about that and agreeing it with them. Consider company property. So do you want them to give in, their laptop and things like that before they go on their garden leave period? Do you want them to be communicating with your staff and customers while they're on garden leave? I'd put your rules on this in the clause. And we've already spoken about whether, having that think of what do you need from your handover, and do you want them to be sitting at home just being available and doing nothing, or is there something that you want them to be getting on with while they're on garden leave? So that finishes us off. 12 and 30 minutes was a bit ambitious, so that was a real quick run through and pretty high level. But if anyone has any questions, I'd be happy to take them. Contracts are pretty heavy for this time in the morning, so if we've got none, and you think of one later, if there's anything in your contract and we question, just feel free to send that through to me.
Thanks, Amie. This is Michelle. Nothing from me, but that was really good. There were a couple of wee things in there that I'll need to go back and check in our contract. So,
I feel everyone's going to be a bit nervous now.
No, it's all in there, but the
Yeah.
semantics sometimes, need to get checked. So no, that was great. Thank you.
No, it's a good time to do it with the new year coming in, everyone. So no, thanks very much. Oh, have you got a question? That's maybe an accident. Well, thanks very much, all. And again, if anyone thinks of anything, just ping your question through to me.
Thanks, Amie. Bye,
Thank
everybody.
you.
Bye.
Thank you.
Thanks, Amie.
Thank you.